We'll call the next case, Drouillard v. AAI.
Good morning.
Good morning.
Mark Ronzotto on behalf of the plaintiff appellant. Since I'm a bit more interested in what you're thinking about this case than what I'm about to say, I waive any self-imposed limitation on the asking of questions. The drywall was stationary. It was resting in the road when the ambulance hit it. It was a matter of seconds, but it was in fact stationary. This is not a case, therefore, in which the drywall fell from the mystery white pickup truck on top of the plaintiff's car and injured him, hitting the plaintiff's car. This is instead a case in which the ambulance hit the drywall. So in that sense, the Court of Appeals was correct. The ambulance hit the drywall. On the other hand, the drywall made contact with the ambulance. There's no question about that as well. And that basically presents the question that's before you in this case, and that is, does this policy language mean to hit in the sense that the Court of Appeals majority found, or does making contact alone satisfy the uninsured motorist policy provision of the contract? I have, in my brief to the court, presented three reasons why the Court of Appeals was incorrect in failing to give contact the preeminence it deserves in this context. Normally, you would expect an appellate attorney to give you the best argument and go in descending order of importance or strength. I elected, for reasons that weren't apparent to me in going over my brief, to do it the opposite way. I went from the least important argument in support of my position to what is the best. But I'll remain true to my brief, and I will in fact go in the same order I went in my brief. And the first point I made was that the trial court was correct in recognizing that there is in fact a dictionary definition of the word strike or hit, which does in fact just require contact. It was in my brief, but interestingly, an amicus brief from the defense side made the same point for me and provided another dictionary definition of the fact that the word hit can in fact just mean to make contact. Let me go to my second point. I'm sorry.
Before you go to your second point, I'm not sure, I don't know how to rank all your points, but putting that aside, if the dictionary definition or the definition that we find is to come in contact with, that's an attractive argument for you, but it's also true, as Judge Talbot wrote, that we don't usually say my face hit your fist, right, or the window hit the ball. And so do those two things have to be equally likely to be the way the parties might have intended the language for a jury to decide, or how do we weigh them against one another?
Yeah, the point is, I think my point about descending order should be accented at this point. I think what I would make of my first argument is that the word hit can be interpreted as to make contact with. Obviously, even in the amicus brief you got from the defense side in a footnote, it was the third definition, that is to make contact with. I acknowledge that there are scenarios in which it can in fact, must or will be defined as the Court of Appeals majority defined it. Let me go to my second point, ascending, if you will, and that is I went through for the court a history of these uninsured motorist provisions. And the history is important because unlike a lot of other contracts, it seems to me, insurance contracts, which are not negotiated as far as I know, can have case law backgrounds behind them. And this is one such case, because what I did in tracing back the history of this, you discover that uninsured motorist policies are a relatively new invention. The first mention of an uninsured motorist policy in the state of Michigan is a 1965 case of the Court of Appeals. The first case to actually address a hit-and-run accident was in 1966, the following year. And for a period of 27 years, every hit-and-run accident that reached the appellate stage, both published and unpublished decisions of the Court of Appeals, had exactly the same contract language, qualifying language with respect to hit-and-run vehicles. And that was, there had to be physical contact. That was the standard language used for a period of 27 years. In 1993, the first case got decided by the Court of Appeals that didn't have physical contact. And you see a second generation, if you will, of hit-and-run policies, uninsured motorist policies, which deal with more aligned with what we're dealing with here, which is hit or strike. They required that the unidentified hit-and-run vehicle hit or cause an object to hit or strike. The physical contact language was no longer, well, it was in some of the policies, but as of 1993, there was different language introduced. But what is very important from 1993 until this case, there was never a single case which did not equate the word hit or strike in this type of policy with physical contact. In other words, from 1993, with the introduction of this concept in Krieger in the Court of Appeals, the court consistently, this is the Court of Appeals, consistently ruled that when the language of the uninsured motorist policy said hit or strike, it meant physical contact. Now, there was a reason behind that in terms of the insurance company's interests, and that is they wanted to weed out fraudulent claims. They wanted some physical contact between the vehicle, whether it is direct, as if the mystery white pickup truck struck my client's vehicle, or causing an object to hit, indirect. The fact is that until this case in the Court of Appeals, there was not a single decision from the Court of Appeals which construed the language of either hit or strike in a policy of this type, which ever said that it didn't equate with physical contact. Now, let me move on to my third point and my best point, and that is the defendants have taken the position in this case that, or the Court of Appeals did as well, that the word hit requires, it does not require physical contact. All you have to look at is whether the ambulance hit the drywall or whether the drywall hit the ambulance. That was the rather simplistic version or the simplistic view of the Court of Appeals majority in this case. The defendants in this case and the Court of Appeals failed to read the entire provision. It's not very long, but the entire provision is very important to this because the hit and run provision of this policy is 3 sentences long. It's on page 11A if you're interested in my appendix, and you can, the provision I'm looking for is 14A of my appendix. But the second sentence of this particular policy is the one that was the focus of the Court of Appeals opinion, and it says the vehicle must hit or cause an object to hit an insured or the insured's vehicle. And it was that on the basis of that sentence that the Court of Appeals rested its decision. They ruled that, of course, the drywall did not hit the ambulance hit the drywall. But it's the next sentence that the Court of Appeals failed to read in the policy language, because the next sentence says, if there is no direct physical contact with the hit and run vehicle, It then requires some additional verification of the fact that the accident occurred. Now, what's critically important about this third sentence is that it is a reference, a clear reference, has to be, or else the defendant is really in trouble in this case. It has to be a reference when it says if there is no direct physical contact with the hit and run vehicle, that has to be a reference to the second way in which the hit and run provision of the previous sentence can be triggered, and that is causes an object to hit. That is a direct reference to that. Okay, it must be, or the fact is this policy would, if it's not, if it sits on its own, there's an interesting Illinois Court of Appeals decision, which I've cited, I think, in about the last footnote of my opinion, of my brief, in which it construed exactly the same language of another policy, obviously, but almost exactly the same language, and said that this provision, this third sentence, is divorced from the second sentence, and on that basis, it found the whole thing to be ambiguous. I'm willing to concede that this third sentence is, in fact, a reference to the second sentence and its provision of causing an object to hit. But what's so critically important about the third sentence is that it doesn't use the word hit. It uses the word if there is no direct physical contact. That the point of this is that the contract itself defines hit. It defines hit the same way that third definition of the Merriam-Webster dictionary defines it, to have contact. It defines it the same way that the Court of Appeals for the last whatever years, since 1965, has defined the word hit or strike in a policy of this type. So the fact is that there is, and obviously everybody knows you're supposed to read this policy language as a total, as a complete total. But there is actually in this policy an actual definition of the word hit, which does in fact incorporate the words direct physical contact. And it's very interesting to me and very important to me that two people have written briefs since I wrote my brief in this case. The defendant and a very fine lawyer wrote a brief for the Insurance Alliance, they call themselves, and neither one can address this question. Neither one can address what the third sentence of this provision, it's not a long provision, it's only got 3 sentences, neither of them have addressed what the third sentence adds to the second sentence and why it makes a difference in this case.
Thank you. Would you like to reserve your time?
I'd like to reserve it. Thank you.
Good morning, Your Honors. Michelle Riker-Simone on behalf of AAIC. I'm not going to say the long name. That's okay.
I blew it. Yeah.
That's all right. Just don't call me late for dinner. That's all I ask. We are asking that this court deny this application for leave today because we think that the Court of Appeals got it right. The Court of Appeals took a look at the uninsured motorist provisions in this policy and applied the long-standing rules of contract interpretation as enunciated by this court over the years. This is not a one-time, one-off type of situation. This court has long said insurance contracts are interpreted like any other contract. Intent of the parties based on the contract language. Goes back to, I don't know how far, but I believe the first case I quoted in my brief was 1913. And I'm not going to bore you with reading all the sites because I know we've killed a lot of trees in this particular case. And essentially, the definition of this hit and run vehicle, the definition of uninsured motor vehicle focuses on hit and run vehicle. And in this case, I think it is important to take a look at that says the vehicle must hit or cause an object to hit. And again, appellant would have you ignore the rules of contract interpretation that they don't agree with, that they don't like. This court in 1893 says that contracts are interpreted in accordance with the rules of grammar. That is exactly what the court in this case did here. They took a look, they did the analysis, and they made sure that they were comfortable with that particular grammatical rule when they looked at cause an object to hit. And I don't disagree that there are different kinds of physical contact. There is direct physical contact. Another vehicle hit a second vehicle. That would be the first portion, the vehicle must hit. We don't have that here, and I think everyone's conceded that. I believe everyone's conceded that this policy language is unambiguous. We just look at differently how we read it. Despite the fact that everyone says it's unambiguous, the amicus brief for the appellant side tries to create an ambiguity where none exists. The parties don't even agree that it's ambiguous. They say it's unambiguous.
So counsel, if the drywall had fallen off the truck, but the truck was going uphill, so it was sliding downhill when the ambulance came in contact with it, then there'd be coverage? It's really just, like, the whole contract turns on whether the truck was driving uphill or on a, flat surface when it dropped the drywall?
Well, Your Honor, I believe that's the laws of physics.
No, and it's that simple. Your answer could be yes, Your Honor, that if the truck had been going uphill, then the ambulance driver would be in luck. But it wasn't, so he's out of luck.
Well, that's true. This object was stationary. This is no different than if you look at the Seeger case, Seeger versus Hartford, which addresses this exact same policy provision language, and in a similar circumstance where the hit and run vehicle didn't make direct contact, but the accident vehicle hit a tree. This is no different than a tree, a light post, anything like that. And again, we go back to all the other examples that came in. I wanted to bring visual aids this morning, like a bat and a ball or a nail and a hammer, but I didn't think they'd let me through security with those. So I opted not to.
Can you address your opponent's, I'm sorry, I'm over here. Over here.
Sorry, Your Honor.
Your opponent's argument, I think, about the importance of that third sentence. I note that in your brief, your definition that you cite doesn't even include that third sentence. And so I'm curious, and as he pointed out, I didn't see an argument addressing what is the import. They make an argument that it informs the definition of hit. So what is your argument as to the importance, or what we're supposed to do with that sentence?
Well, first of all, I disagree that it defines hit, because under appellant's scenario, anything is then an uninsured motorist situation. And if you go back through the history, if we talk about the history of uninsured motorists, I think that is important, because the first cases in this state that dealt with the concept of uninsured motorist and indirect physical contact developed a judicial test, the substantial physical nexus test.
Right, but aren't we, those cases deal with where the definition says physical contact. And so we're saying, is direct the only thing that's allowed, or is indirect where you have, an intermediate vehicle or something? We're not dealing with that, because there's no question that we have physical contact here. So what does, when they say vehicle must hit or cause an object to hit, I think that phrase actually sort of separates it from all these prior cases, right? Because the policy says we're not going to deal with direct versus indirect. We're saying cause an object to hit. And then it goes on to say, if there's no direct physical contact with the hit and run vehicle, why doesn't that say what we mean by hit is direct physical contact?
Because the particular situation and scenario, there are a zillion examples that we could come up with for an uninsured motorist situation. And unfortunately, I haven't thought through every single nuance of that. But I think that is in the situation where I think you go harken back to the cases that talk about phantom vehicles, and there's no object. For example, what happens if, I'll use a hypothetical here, what happens if the drywall, the ambulance swerved to avoid the drywall, didn't hit the drywall, and rolled over. That's the type of corroboration that particularly that sentence is designed to address, I believe. It is not, it doesn't talk about the object causes to hit. Did that truck actually cause the drywall to hit the ambulance? It would be different if a piece of drywall came off and flew and hit the vehicle, covered the windshield, and the ambulance driver couldn't see. That's a different kind of physical
Would you agree that
contact.
if the ambulance hit the white truck, not the drywall, but clipped it at the end and the white truck drives off, if it was the ambulance that hit the vehicle as opposed to the vehicle hitting the ambulance, that there would be coverage?
That's a different scenario, Your
That
Honor.
would be
because
to
that's
hit.
that's the first part of
So
that
the
sentence.
meaning of
Vehicle
must
hit.
So the meaning of must hit is different than 4 words later to hit.
It causes an object to hit. For example, if something flew off the back of the truck, a piece of cargo, not a stationary. If you look at all the other cases where things have flown off the back of vehicles, that's causing an object to hit if the load isn't secured, that kind of thing. This is not an issue or a situation where the object itself is moving.
So the vehicle must hit can encompass the uninsured vehicle hitting the insured vehicle or the vehicle
Correct.
that, or it could encompass the vehicle in which the insured is riding hitting the uninsured vehicle.
Yes,
Or the hit
because
and run
that-
vehicle. So in that context, vehicle must hit. It doesn't matter who's the subject and the object, right? But in the next phrase, it does matter?
I think so, because both of those, if you're in the scenario that you're describing, both of those vehicles are exerting force and they're both in motion. It's a different subject-object, from the standpoint that a stationary object,
Well, it doesn't say the vehicles must hit each other. I mean, in that case, it says the vehicle, meaning the hit and run vehicle must hit a covered auto.
right,
So, and then it says cause an object to hit. Isn't it using the same subject object? And if you're saying that as long as they're both vehicles, it doesn't matter who's doing the hitting, but if it's an object, it does matter.
yes.
Okay.
Can I follow up on Justice Kavanaugh's question, just to
Yes.
understand as clearly as I can? In part, I think your answer is, this would be relevant in responding to the question that Mr. Granzato asked just before he left the podium. You're saying, as I understand it, that the direct physical contact language is not designed to give additional meaning or to supplement in some way what it means to cause an object to hit. What's the object? What's the subject, to use Justice Kavanaugh's language? What's the subject? What's the object? What's the object? What's the subject? But rather, that term is designed to differentiate the evidentiary burdens for uninsured motorist benefits in those cases in which the cars have hit each other and in which the cars have not hit each other.
Correct.
Is that a fair summation of what you're saying?
I believe so, Your Honor.
Is there something unclear about what I'm saying that causes you to be uncertain in responding to me?
No.
Can I follow up as well?
Sure.
I find it sort of ironic listening to your opposing counsel, his view that the third sentence does not create a third category of liability, but if I heard you correctly, you ironically take the opposite view, that the third sentence applies and there would be coverage where there's no contact with the ambulance and the projectile or the drywall or the other vehicle. So you said if the ambulance swerved to avoid it and rolled over, this third sentence is there because we need to have witnesses, and then your client would pay on that type of a claim. Is that's the position you're taking today?
Potentially, Your Honor, that was obviously a hypothetical situation, and we're not dealing with that directly. And every claim is so different And it's hard to,
What if I thought that if that claim arose, your client would deny coverage and not take that position? Would that, in other words, it's hard for me to believe your client's going to take the position that there doesn't have to be any contact with anything for there to be coverage. Based on this provision, I should say, based on this policy provision.
and I guess I would have to concede that, Your Honor, that there does have to be the physical contact aspect. That's what the purpose of this particular provision is the physical contact. We have two different kinds, two different circumstances. We have the direct, the vehicles hitting each other, exerting force, and then causing an object to hit is the indirect.
I just had to get back on planet Earth. I couldn't have the plaintiff arguing for a narrower provision and the defendant arguing for a broader one.
And I appreciate that, Your Honor.
Counsel, can I ask a question? And
You certainly may.
Thank you. I just want to follow up on the chief's question, which was the idea that if the truck had been going uphill, then you're indicating that you would have had contact because the drywall would have been in motion, correct?
Potentially, yes.
So let me ask you a question. How can we be certain in this situation the drywall was not in motion?
Well, that comes, Your Honor, from all of the unequivocal testimony regarding the drywall and its status.
How fast I guess the question is, why isn't this a factual determination, that we should send back to the lower court? And I guess how fast would it be required for the drywall to be moving? If it's moving at all, correct? Would that then go to Justice McCormick's question, which you acknowledged would be contact, right?
Well, that's the question, is the stationary versus the force. If the object is exerting any type of force, I would have to concede coverage potentially, depending on other circumstances of the claim. But just in that particular hypothetical.
Right. But let's go to this case, though. You can't say with certainty that a piece of drywall that flew off of a truck that landed in the road wasn't not dynamic. I mean, the object is a dynamic object, and you can't say unequivocally, you can't say right here say that there's no way that this object wasn't moving, correct?
Well, that's based on the factual testimony, Your Honor.
But the factual
it's a
testimony-
2-foot stack of drywall. It's not just one sheet.
But you have testimony where there was some discussion as to the amount of time, and you have some issues here as it pertained to when the drywall came off the truck. So objects of that size are still. Would you be willing to concede the fact that objects of that size could still be in motion depending on the time in which it fell off the truck and the impact with the ambulance?
Well, I guess potentially it could, but the testimony doesn't support that, because the driver of the ambulance said it was stationary. The passenger of the ambulance, who is the actual plaintiff appellant here, said it was stationary. All the witnesses, regardless of the number of seconds or minutes or however long they said between the time the truck cleared the intersection, all stated it was stationary.
What I'm a little confused by is the legal question, which is motion. If something's moving a millimeter, is that still moving? I guess that's my question, is that what I'm trying to understand is from your perspective, what would it take for an object to still be moving? If it's moving, things still move, right? If it's moving, if it came off and it's still even in motion, just a little bit in motion, would that then create, going back to Justice McCormick's question, the fact that, hey, it was going uphill, so it was still in motion? I mean, does the speed, I'm just trying to get to the sense of if it's moving at all, even just so slightly, it would still be in motion, correct?
Well, that I can cite back to a lower court opinion from quite some time ago with respect to a tire rim and assembly that was actually they said it was circling like a dime in a lane on a road. And I believe that's the Kirsten case. And they decided that there was no uninsured motorist coverage in that particular situation because there was not enough of a causal connection. And again, that goes back to that substantial physical nexus test.
Counsel, can I take things from the metaphysical just to the merely theoretical? The testimony was that this drywall was dropped and either 3 or 30 seconds later, it was struck by an ambulance, right? So there wasn't a lot of time that went by.
Correct.
Unlike Justice Bernstein, I'm willing to concede at some point the drywall was in motion and at some point it came to rest. That's my rudimentary understanding of the laws of physics, right? I didn't
Yes.
do well in physics, but I got at least that far.
I guess I should have brought you all apples in representation
Right,
of Newton
Newton.
this morning.
So we're trying to figure out the intention of the parties. I agree with you. That's our job.
Yes.
So why would it matter to the parties whether an object was in motion or whether it had just come to rest? So in other words, if it was a basketball that fell off the back of the pickup truck and it was still bouncing, or the drywall that at some point was in motion, but in a matter of seconds, literally seconds, came to rest, how is that different from a coverage standpoint, liability standpoint?
Well, it's based on the policy language, Your Honor. I really wish I could give you a concrete example of what you're asking to differentiate where there would and would not be coverage.
But the policy doesn't say in motion, right? You're
No.
inferring that to cause
To cause an
infers
object to
that
hit.
it requires some kind of motion or through force or something like that. But you're inferring all of that from the word to cause,
Correct.
because the physics that we have discussed, I
Right.
did take physics, actually,
Yeah.
is
So
not
but I
mentioned.
don't want to talk about it.
Is not mentioned anywhere in the policy, though, right?
In terms of force and the laws of physics,
Motion.
no, they are
Or
not.
motion, even.
Well, no, other than in that provision that the vehicle must hit or cause an object to hit.
Okay. Thank you.
Taking this from the metaphysical to the theoretical to the meteorological, do we need to pay any attention to the weather conditions that day?
I don't believe that's relevant, Your Honor. I don't believe there's any testimony with respect to the weather. Thank you,
Thank
Your
you,
Honor.
counsel.
I'd like to make 2 quick points, if I may. Justice Viviano, your question with respect to this third sentence is exactly on point, because if my opponent is willing to concede that it's not connected to the second
You
sentence.
go along with that deal? You'll make that deal right now?
Well, I would.
Maybe they won't help
then
the client in this
I will.
case, but-
I'll change my entire argument. The fact is, you should read Pritchett. Footnote 6 of my brief is the Illinois, I think it's Court of Appeals, decision in Pritchett, because Pritchett says that that third sentence could in fact be divorced completely from the second sentence, and almost exactly the same policy language. And if it is, then the entire policy is ambiguous. And that almost goes without saying, because you have one sentence that says hit or cause an object to hit, and then the third sentence, if she's willing to acknowledge, is standalone, then there doesn't have to be any contact of any kind. And that was a bridge too far for me when I wrote my brief, because I consider them to be connected, and I consider the third sentence to define the second.
And we've met, so you know how we roll. So
Yeah.
there's
And
that.
may I just make one more comment? Justice Kavanaugh, you asked my opponent, what does the word hit mean? And she's talking about cars and moving cars and whether it makes a difference. My opponent is not a published decision of the Michigan Court of Appeals. What my opponent says here today means nothing in terms of how this policy is going to be implemented or interpreted in the future if this court doesn't do something about it. Because the opinion of the Court of Appeals in this case does define those words that you asked my opponent, and there is no question that what the Court of Appeals decided in this case, and that is this vehicle, if it's going to be covered, the vehicle has to hit. And that means that if we had take one scenario, somebody going through a red light and a green light. My client is going through a green light and a car is going through a red light. If my client happens to be hit on the side because he beats the other vehicle to the intersection, okay, that is covered. That's what the Court of Appeals has said. On the other hand, if that car that runs the red light beats my client to the intersection and my client runs into them and that car runs away and my client is injured, that's not covered. That's the bottom line on this case, because it has to hit. Okay, if they didn't hit, it doesn't matter what my opponent says to you in oral argument here today, it's what the Court of Appeals said. And what the Court of Appeals says, no, it's got to hit. It's got to hit the vehicle.
Well, would you agree, though, that if that is true, I understand your point about the Court of Appeals opinion, but if what counsel said was true, then the meaning of the first word hit would be different than the second word hit.
Well,
I mean, would be inconsistent then, right? I mean,
well, yes, I agree with that, which is
Okay.
obviously not the way we construe contracts.
okay.
Thank you.
Thank you, counsel. The case will be submitted.